in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her at night. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial, we pay the price.
Heyo! Welcome to day 164 and recap of directed verdict hearing motion thingies. Yeah, we are getting so close. So close. I suspect tomorrow will be, well, the jury has to get everything read to them. The jury instructions, any curative instructions, and stuff. But we might be at closing arguments tomorrow, Thursday. So hopefully I'll be home on time to do that live, all of it. And if I don't, I'm going to try to ask Dave to at least start the stream for me. And then I will turn up as soon as I humanly can. Hello, folks, by the way. Hello, GD. Hello, Kristen. Mike. Laugh, I always have fun. Kristen, Porcelain. And everybody who just tuned in. Yeah. There's not much to say. Now, I do know a thing or two about what went on today. But I also know that some of you wait for me to do this. And therefore, no spoilers, please. And let's see if Judge Whittaker can un-F this cluster F. Oh, coffee. All right. Let's go into it. So I don't think there will be any sidebars today, by the way. All right. Sound on. Closed captions on. And here we go.
All right, I saw we have a written motion for directed verdict on behalf of Mr. Kendrick. Is there a separate one for Mr. Stillwell?
No,
or you?
mine's gonna be one.
Okay. All right, Mr. Kendrick, you want to present yours? I haven't had a chance to read it, only see that it got.
It was last minute, Your Honor. So.
No problem.
Good morning, Your Honor.
Good morning.
Okay, the camera is a bit off. Hold on while I place myself up there instead. Okay, for now. There. Okay.
Let me begin just by stating that Mr. Shart and I last night went through a number of the predicate acts and overt acts that are in the indictment. And We've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Shart speak to that when he makes his motion orally this morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment.
Yeah, I remember they have a huge argument about this pre-trial with Judge Glanville, what was actually counted as overt act in the end. And I have this vague recollection of Glanville not ruling on it, but referring it forward. And I expect if we had Judge Glanville here, he would have said, nah, we're going to take all of it.
Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking.
And I completely agree with Doug here. A rational person should not get to a guilty verdict in this trial. Problem with directed verdict is that it's all on the defense to show that there isn't even a shred of hope, and the judge has to look at everything in the best possible light for the prosecution. This means it is an insanely high standard for the defense to overcome. Insanely high. Directed verdict, even on a few counts, even on all of it, it's extremely rare. Most attorneys goes through their entire careers without seeing one the directed verdict motion being granted. On this show, we have one of those. It was back in, I want to say, June of last year in the, let's see here, which one was it? Which one was it? I know this. Darn it, I had it the other day. Michael Turney. Yeah, the Michael Turney case. And that was in, that was some time ago. Yeah. But the playlist I have on my channel, if you want to see exactly how bad a prosecution has to be, how extremely little evidence, zero evidence it has to be for a directed verdict. And it is That trial was not that many days. So it's if you have nothing to do over the holidays and want to see, oh, this is how bad it actually has to be. It is the Arizona versus Michael Turney case. I have a playlist on my channel. And oh, that was really, really bad. And in the end, it seemed like even a prosecution agreed with, yeah, we never actually had anything. And yeah, that case was a social media phenomenon because the missing girl's sister has a very successful blog and vlog about this. So it became a political decision to try that case, which is coincidentally, I believe that so is this trial. And but once they got to trial, yeah, there was actually no evidence that Michael Turney killed his daughter. Absolute zero evidence. Being a bad dad does not mean you kill your children. All right, let's continue here.
To achieve an overall common goal as required by the law. The state has shown a number, quite a few, I would agree,
Hey, Dave.
a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient.
Again, completely agree. Oh, now the camera starts moving around. Okay, let's place myself down there so I don't cover Doug's head. Yeah, they never pulled any financial records to actually show the funneling of money from people to the gang or the central figures, and nothing from Mr. Williams saying, oh, look at all the millions he made and what he did for the gang with it. Well, yeah.
They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac and inside of the Texaco station. This Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti.
Okay, just a quick break here. From Joseph Papp on Twitter. Closings will be on Monday. Okay, that was unexpected. I assume she doesn't want them deliberating over the weekend. Okay. Which means Thursday and Friday. We okay. Yeah, let me think of something. Hey, Catnut Williams raid. Hey, hello. You are just in time for my recap. Right on time. Hey, Cat Raider. Well, Cat's still there. She's still alive. Okay. Maybe she will send the rest of you over. Okay. So we are going through directed verdict, hearing, motion, and then a bit of the how they will manage to do the jury charges. And yeah, so that is what we're doing now. Remember, folks, a lot of people are only watching the recap. They actually haven't heard anything yet. So please no spoilers. Okay? Let's continue.
And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas.
Again, completely agree. The Donovan Thomas murder, for me, there's a reason why Mr. Stilwell is still, to this day, only charged with it 9 years later, because there's not enough evidence. There's not even close to enough evidence to actually bring him to trial. But mixing it in with a whole lot of garbage, the prosecution are trying to make it stick. And for me, it's not even close. But then again, Lil Rod was convicted of his murder charge. Despite, and we saw that on the stand with the witnesses, Oh, he was railroaded. Oh, he was railroaded bad.
Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there's an essential element of 133 that has been left out. So I believe a directed verdict on 133 on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again, to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor.
Sadly, I have to agree. I think it's so unfair, because the Martinez case is the only case, more or less in the entirety of the United States, that has somehow allowed the state not putting in a lesser included, but moving in with the higher charge. And after they rested their case, and I believe in the Martinez, even after the defense case in chief, which technically we have had here, they were allowed, and it was upheld in appeals court. I believe it's a really, really bad decision, the Martinez case. Really bad. Just another one of these, let's make it easier for the prosecution to convict even after they screw up royally.
And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I mean, I guess there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right?
Yes.
Yes.
Yeah, I believe that's
Okay.
right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you.
All right,
Mr.
thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay. So I have arguments regarding several different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with the this argument applies to the RICO count.
Can I ask you something
Yep.
before you get
Yes.
started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I
is it-
don't. I don't. A chart is overstating what it is.
Okay.
We went through. We were trying to determine what specific counts, what
Okay.
evidence has been provided to the jurors so far in this trial.
Okay.
So let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with a longstanding presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, E-L-O-N-I-S v. United States, 575 U.S. 723, it's 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. Count 1, RICO. Mr. Stillwell and Mr. Kendrick, to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly.
Mhm.
The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO
Mhm.
case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly.
This Mr. Steele Mr. Steele argued this same argument before Judge Glanville pre-trial, before even jury selection began. And if I remember correctly, Judge Glanville actually ruled against it, this very argument. But it's a new judge, and I understand why they repeat it. I understand why they repeat it. So this is this shows me that Mr. Steele is still in the background somewhere, trying to help, because what Mr. Shard is I believe is a good argument. Problem is, we're in Georgia, in Fulton County, and it should be approved because it's another one of these incompetent oversights from both the prosecution and from the grand jury. They missed out on a crucial element. But here, we're in Georgia.
The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614.4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, or I think it's Weitzel, v. State 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Weitzel case supports that. So, Your Honor, we believe that the RICO count 1 is missing an essential element that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement is missing from the indictment, count 1 is subject to a directed verdict, a general demurrer and directed verdict, as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people. But additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. The indictment in this case for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment, as the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demurrer and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin in it.
Just a second.
Thank you, Denise, for $5 super chat, saying thanks for the recap. You're very welcome. You're very welcome. For SM1, finally catch you live. Yay! Yeah, thank you so much. Yeah, this is, I'm not saying it is identical to Mr. Steele's argument before Judge Glanville, but it's close enough to me to understand that this material was handed to Mr. Short from Mr. Steele. And it should have worked, but we're in Georgia. Contact your local politician and tell them the RICO, the Georgia RICO, needs to be revised, overhauled, because this is ridiculous. We can't spend $15-20 million each time some underachieving district attorney wants to make politics.
And Mr. Abate just gave me, just helped me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you. Okay, go ahead.
So moving on to the overt acts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged
Well,
overt
can-
acts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, you know, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence.
First of all, thank you to Deja Vu, gifting 5 memberships. Thank you so much. Everybody say thank you to Deja Vu, bringing our new members of today to 5. And it was gifted to Shine Eyes, Kimberly Bono, Infinity, Emma Louise, and Mariana Morse. Heyo! You now have access to all the members-only perks on my channel. Yay! Thank you so much, Deja Vu. And now, Mr. Short is about to go into the absolute lack of evidence.
With regard to count 2, because Mr. Weinstein was basically talking about, you know, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by 2 individuals, one being Quindaria Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution. And we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed. And then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street. And his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire universe of the evidence against Mr. Stillwell. And our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So moving on to the alleged overt acts. And I'll point out in this indictment, it lists, this is a conspiracy to commit RICO. So they don't need to prove the predicate acts. They don't, those 2 related events within 4 years, they don't need to prove that, because all they need to prove is a conspiracy and 1 overt act. So,
Well, a conspiracy to commit 2 interrelated racketeering acts in furtherance of the enterprise.
yes, okay, that is fair, but they don't have to prove that the
That they
acts
occurred.
actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of a conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overt acts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overt acts. They identify everything as an overt act, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity.
Mhm.
The nature of this allegation is a conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overt acts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So I, as a general principle, I do not understand if they only need one overt act, okay? And that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to
It's
convict.
not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they
So
also have to prove a conspiracy and an enterprise. And so,
they do have to prove a conspiracy and enterprise, and I'm not arguing that they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things, but they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act.
we're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict
right.
that.
Sadly, again, we are in Georgia and the Georgia RICO Act, which allows, beyond this 5-year span, between May 9th or something, 2022, back to May 10th, 2017, the 5-year span, they can still find the conspiracy further back than that through the overt acts, but they can't find they can't use it to they can't find an overt act outside of those 5 years to be unanimous on as, yes, we found them guilty on this overt act, because those overt acts does not count other than to show conspiracy. But within the 5-year span, which coincidentally, Donovan Thomas murder is not within those 5 years, but they still brought all of that crap in. And so the 5-year, luckily, the 5-year will make it a bit easier for the defense to argue against in closing arguments, I believe. But still, it's such a faster clock. Such a faster clock.
You find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not. believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find something, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
Okay, and
I mean, that's not exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point,
Yes, you caught alive.
it is mere
Surplusage.
mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts for the overt act element of the RICO conspiracy.
Mm.
So, and then additionally, Your Honor, in all candor, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, over the evening and this morning to go through those, and we either said we're not challenging it. We recall that there was evidence that would survive a directed verdict.
Mhm.
We were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but it's a long list, and probably I would suggest to Your Honor for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
What's that? Yeah, but
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss with defense
All right,
counsel.
I
those
can
acts.
certainly let y'all do that. And if there's some that, I mean, I know there were at least a few that no evidence got presented on. So to the extent y'all can reach agreement, that would be fine. And then if we want to take it up later in the afternoon, after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you. Your Honor.
And there may be some y'all want to argue about, so we can do that later. So that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right. I've argued the gang counts.
Oh, right, and yeah,
And I've argued the RICO. The Shamal Drinks alleged murder. I
mhm.
think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. We heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video that Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test that we have no muzzle flash.
Mhm.
It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue result. And we heard from Mr. Coven from GBI. He followed all the procedures. Although there's been speculation and of course the grave suspicion jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the Drinks murder, as well as the associated charges with the Drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element. And we're going to argue that the state should not be able to alter on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well,
if
I
it were
think it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
Okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of maybe not surprise, but the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.
Your Honor, to aid an argument for the court, I'm going to be addressing the demurrer regarding count 1 RICO. And if the court has further questions on the lesser included of the 131, Mr.
Oh God, here he goes. Mr. Abadtai is a walking, talking 403 objection, in my opinion. Ugh. For me, Mr. Shard makes excellent points. Excellent points. And there are states in the United States where this case would have been thrown out long ago. And with the directed verdict motions, I mean, directed verdicts are so rare. Never expect a directed verdict. Never expect it. You have to motion for it, for appellate issues, for appellate reasons, but they are so hard to find. Okay, let's listen to Mr. Abadtai.
Abadi's going to
Okay.
address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the Demurrer on the street gang, if the court has more questions on that, and then Ms. Hilton would handle the remaining counts other than count 1. I just wanted to give the court that overview.
Thank you.
As the court's aware, Your Honor, the charge as alleged, the conspiracy, the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with which is count 12 of the indictment, and the 3 criminal objectives as the court outlined in our proposed
12.
page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient because there's
Right. I mean, if the state is
Oh yeah,
alleged two
Atkins.
different ways
Sorry,
of
Kristen. Yeah,
the
Atkins.
defendants having violated RICO.
They are all walking, talking 403 objections on the prosecution side, with the exception of Mr. Floyd. Mr. Floyd. Now that is a guy I want to sit down with over a beverage and have a discussion regarding this RICO. Phoebe Purvis. Ha, Nick, you're really funny, but most importantly, one of the nicest peeps on YouTube. Oh, thank you. Thank you so much. That means a lot to me. That means a lot to me. Okay, folks, you might have seen that I am slowly and surely decorating this space for Christmas. Now it's getting cold outside. So I got myself Christmas socks because you need to take care of your feet. You need to take care of your feet. I hope these fits. I'm not that bendy. Oh. So, Christmas socks on. Mr. Jingles is somewhere around here. I'm actually not sure where. I heard the cat door, but I'm not sure if he went in or out. Oh, those are warm. Warm socks. All right. Back to trial.
Through a RICO conspiracy, and y'all only have to prove one. You don't have to prove both.
correct,
So
Your
you're
Honor.
saying there's at least evidence as to the overall purposes, Part B of RICO.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have from the defendant's own words there and tattoos, their allegiance to YSL. I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris, 695 F 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors. Jewelry, clothing, all of those are just three to start. You also have tattoos, which are permanent. And so Mr. Kendrick has slat on his left forearm and a large snake that was introduced, I believe.
Okay, I have my Vegas arm with the slot machine. Does that mean I am in support of the Vegas mob? No. No. Everybody, Ken's counseling couch is a Sark account. It's very sarcastic. And but listen to the mods, please. Sometimes you're walking the edge.
Yesterday or day before on his stomach that goes up to his neck. You have defendant Stillwell, who has multiple admitted exhibits and posts that reference slime or reference his, for example, exhibit 430 VV is defendant Kendrick, Overt Act 133 with a red bandana and a YSL pendant. State's exhibit 511 VV as admitted is Overt Act 138 is defendant Kendrick with a hat with a rat crossed out on it. State's exhibit 38 November is Overt Act 134 where you have Kendrick pointing at the cameraman, two individuals with Make America Slime Again. And I could go on and on, but the point being, you have both 2015
Do the prosecution understand how much promotion they do for the merch that is Make America Slime Again? I would imagine the sales are through the roof of that thing. I've seen the t-shirts. I've seen the ball cap. Oh yeah.
exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters
No,
of Mr.
you
Zachary.
don't make me mad.
Twitters
But,
of
my mods are looking out for me, Ken. It's just them watching out for me, because if you stir things up too much, my chat might get me in trouble. That's it. So
defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance, coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which is captures Overt Acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Kondo, who rented the Hertz rental.
Oh, yeah, sure. Oh, he confessed. No. Brooklyn gifted a membership. Thank you so much. Getting us to 6 new members today. Thank you so much. That is very, very nice of you. And now, Christy Lamolle have access to all my members only perk. Ken's counseling couch is so sad. This platform has devolved into some level of self-censorship. Yeah, it's annoying. It's really, really annoying. But I can't do anything about it. But I will have a lot of words on Monday during closing arguments. I will have I still have to restrain myself from saying all the words, but I will have Rumble stream up on Monday for closing arguments. So even though, yeah, this is hard, folks, to not say. I mean, during Glanville's days, 50% of my streams were demonetized and stayed demonetized. Since Jört Whittaker took over, 90% of my streams get monetized and stay monetized. A few, maybe 30% gets demonetized. Then I appeal it, and it gets monetized a few days later. So it's a clear difference.
Vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infinity Q50. All of those things combined, that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell. It is that rivalry of a criminal street gang that weaves through this case. And so in terms of commonalities, it is similar offenses, whether it's victims, the method and mode of operating. In this case specifically, you have a number of incidents that involve multiple YSL, self-identified or APD gang detective identified members committing acts of violence together. In Donovan Thomas, you have 4. In Shamel Drinks, you have 4, at least defendant Stillwell, Mr. Garlington in the white Audi, defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion Garlington getting jumped at Club Crucial, there's a 911 call around 2:00 a.m. Fast forward, you have 2 shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers. And you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022 of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in RICO, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the RICO statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public and active allegiance to this YSL enterprise afterwards, that this case and the evidence through testimony and exhibits has established. So the courts, or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yeah, jag tycker just I'm making my 403 here. You're wasting my time. Move on.
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped roundtable of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions. You also have October 1st, 2015, where Martinez Arnold gets jumped at Magic City by Kelvin Watts, Shell Kel, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detective from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actually participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course, one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of David Rito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, there is no evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it's only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members. And that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, the one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder. When YSL members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes, I will take the testimony that has came out related to YFN Lucci or Mr. Bennett, and that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, "I'm on PC with that boy Lucci. How much can I get for that?" Then you have the text messages that were the color-coded charts that Demurrer walked through with Khalif Adams, Demekion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Demurrer of what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
Right, but I mean, a post isn't an act of racketeering. So talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas in 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members.
All right, so which acts of racketeering activity are interrelated that have to do with that?
Yes, Your Honor. So specifically, you have let me grab my indictment, Your Honor, so I can see
Sure.
the accurate numbers. Thank you, Mr. Floyd. So in terms of overt act numbers, you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett.
First of all, now Mr. Atkins is most of what the claims is here, as in the trial, are done by other people than the defendants, which is stupid. But Innocent Bystander Channel gifted 20 memberships. Hey, thank you so much. Thank you. Gifted to Freedom Lover, Emmy, Augie, MJ, Kelt, Rana, William Crook, DZO, Potentially Criminal, Joe Walden, Susie, Susie Q, Caroline, Rachel, Amanda Dawn, Mahmoud, Gina Hart's Poetry, Tracy Turner, Sunday Dollar, W. Smith, Anthony Sink got gifted memberships. Everybody say hi to Innocent Bystander Channel. Thank you so much. Thank you, thank you, thank you. Wow, that's so generous. That is so generous. Bringing our total of members to 26. Thank you so much. Let's see here. Do you have an actual channel? He has. She. I don't know. I don't know. Okay. Here is the link. Go check it out. Let's see here. Yeah. Looks good. No lives, just videos. Looks good. All right. All right. Go check it out. Go check it out. And thank you again. Thank you again.
And you also have, this is not an overt act, but is quite relevant for this purpose. You know, States Exhibit 227 VVB2 is the text message from defendant Stillwell's phone where he says on February 9th at 7:31 p.m., which is, I believe, within 30 minutes of that stabbing, they just wet Lucci's BITCH up, which again shows an us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically a rival gang leader, who, of course, on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rashawn Bennett, Wyeth, and Lucci. And so all of those things combined, without, you have words in the text messages through somewhat coded language.
Christina Molly. I subscribe to IBS channel. No, IBC. Yeah, IBC channel. IBS channel might have other content. An IBS. Yeah, we. Yeah, let's not go there. We are in a very serious moment in this trial.
You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is. They don't need to go into it. You know, the agreement and the enterprise's objectives morph into one and the same in terms of without, they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder, and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within 5 years. Your Honor, I also believe that in terms of an overall pattern, when you have of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, what on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that there is a clear common
If you have to spend 15 minutes circling, and then say, and that is why a reasonable juror can find. If you can't do it in 20 words or less, then it's a stretch.
woven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right. Can you speak to whether it matters that the indictment itself doesn't contain the language willingly and knowingly, willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that
Oh,
much more eloquently
okay,
than
yeah,
I,
That's fine.
if that's all right, but with the
Okay,
court.
thank you. I appreciate it.
Yes, Your Honor. Yep.
And you're going to do that for the RICO and the gang counts, the language,
Yes, Your Honor.
Mr. Floyd? Okay.
Okay. Your Honor, first, what was characterized, I think, as a General Demurrer argument, or an argument that included General Demurrer.
Right.
I listened to it and it was very familiar. It was very familiar because it was made and rejected over 2 years ago in the same case. The rule.
Yeah, and here comes Mr. Floyd ruining the fun. And as he points out, this was argued already against George Glanville.
One case to which reference was made is a United States Supreme Court case. It is not a RICO case. It is nothing like a RICO case. It was a case that involved the federal prosecution under the Federal Controlled Substances Act of doctors who had basically signed pill mill prescriptions, and the application of a federal regulation to that circumstance dealing with the validity of those prescriptions. So not on all fours, not on all threes, maybe not even on all twos. The important thing that matters is the statute. First of all, the text of the statute does not make reference to knowingly and willfully. And so the charge is in the language of the statute, which is sufficient. I mean, that's pretty much the end. That's pretty much the end of that argument. To the extent that the argument blurred into kind of a special Demurrer argument, the point is that first, every defendant is charged with conspiracy. There's no question about who's charged and who's not. It's very clear. It's charged in the language of the statute. Every defendant is alleged to have actually committed acts of racketeering activity. Those require a certain level of intent, and that is proof of the level of intent sufficient to commit a racketeering activity act of racketeering activity has been held sufficient to sustain a RICO conviction by the Georgia courts. They've said there isn't another layer above that. If you have the intent to commit the act and you commit the act, that's sufficient. Page 60, most of this is laid out on page 12, but also of the indictment, but also if you go to page 68, which is at the end of the overt acts, you'll see that we have specifically alleged they were committed in furtherance of the conspiracy, tying every act to that conspiracy, and therefore every individual who committed one of those overt acts to a conspiratorial agreement alleged above that they had the same or similar, which is the test under the statute for relationship. Similar is sufficient. Intents, results, accomplices, victims, or methods of commission, or otherwise were interrelated by distinguishing characteristics. I think Mr. Atkins has well covered that component of it, but it is also specifically alleged here.
Okay, that's page 67 of the indictment.
68.
67 of mine.
Oh, okay,
I-
sorry. You probably have the deluxe version.
Very
At any rate, it immediately follows the last predicate act. So that'll help us all navigate. The point though is that, and this is as true of the Gang Act as it is of this. The cases that have said knowingly and willfully, or the cases that talk about what has to be proven, are not pleading cases. They're not General Demurrer cases. It's just a question of what does the state have to come forward with. Neither statute says knowingly and willfully. Rodriguez is familiar to me. I briefed Rodriguez. Mr. Carlson and I argued Rodriguez. Rodriguez was a facial constitutional challenge. It had nothing to do with the sufficiency of pleadings. And it simply interpreted the statute in light of a vagueness challenge. So not close to being on all fours with this situation. There is no Georgia case of which I am aware that says the state has to allege knowingly and willfully. It's purely a question of proof. That takes us to the directed verdict standard, which is simply could a rational juror find that these defendants acted knowingly and willfully. Most of the argument on that was simply the defense's interpretation of the meaning and weight of the evidence, which is not a permissible consideration in this analysis. The court cannot resolve those issues. And for a case that's directly on point on that is the Evans case, which I believe I cited to you yesterday. It's the other APS.
One thing about Mr. Floyd, he is the scholar in the prosecution's team. usually when you have this specific knowledge about a very narrow subject, you're not often used in trials, but they are using these people to make arguments for a judge. And we should be happy he only does arguments before the judge, because he might have been in the background advising on how to ask certain questions to get the RICO aspects into the different witnesses, but then the prosecution's team has been how is the nicest way I can say this? A fucking disaster. That should yeah, that's nice enough. And I do you guys, sometimes when I pronounce things in English, my Swedish comes across. For instance, when I say fuck twats, I mean 4 quad and nothing else. Okay, nothing else. 4 quad. It's just my Swedish accent. It when I say 4 quad very fast, it sounds like I'm saying something very, very insulting. But really, I'm not.
Appeal along with Cotman, and it lays out the standard in the specific context of a directed verdict or motion in a RICO conspiracy case. And the standard that it enunciates is exactly the same
I
as,
think you cited that yesterday. Can you give
okay,
me
I'm
the
sorry,
site?
it's Evans v. State. By recollection, it's a 2019 decision. I don't have it immediately in front of me, but there's only going to be one Evans RICO APS. There it is. It is 360 Georgia Appeals 596 at 600. The court said the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And thank you. And just since I'm up, the question of, I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. If you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurrers. Even with this indictment, we drew special demurrers with as much
Right, so
detail as it
they're-
has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down to a, if I understand correctly, an argument that there's not sufficient.
Okay. He's referring to a special demurrer. So let's just quickly go through what that is exactly. Let me just check here. Dun, dun, dun. And let's bring it up. Demurrer refers to making a pleading that challenges the sufficiency or adequacy of pleadings of another party. Demurrer typically come in 2 forms, general and specific. A general demurrer challenges a broader problem with a pleading that affects all of the claims brought, such as improper venue. A specific demurrer objects to a particular problem with the details of a pleading, most commonly the failure to claim sufficient facts for a cause of actions. In ruling on a, yada, yada, yada. So the demur from the defense here is that the prosecution didn't bring jack crap to trial. It is so bad. And that is what Mr. Floyd is arguing against here. Now, Judge Whitaker, when it comes to the directed verdict, has to look at everything in the best possible light for the prosecution. It sounds like a wee furry animal to me. Yeah. Oh, Demurrer is living in the Congo desert. It's a squirrel. No. So that is today's little legal lesson here. Okay, let's go. Let's get back to this.
Evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry.
different
Then,
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years,
and
whether it
indeed,
was-
and indeed,
yes, it was definitely okay to put them in the indictment, whether they should go out with the
yeah.
jury.
Okay, I
If
understand.
you weren't, then bring me back to what.
No, I
you
may
were
have,
talking about.
I may have ground the gears a little bit on that
Okay.
one, but I think I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question. If I understand the logic chain from the defense, it is basically, we only have to prove one overt act within 5 years of the day of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument. And it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise, right? This is, this begins, it begins a long time ago. The state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. I mean, at the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them, going back to the Castle Amorisi War of 1932, I think it is. So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. I mean, under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Playing in 1.5. Let's get through this.
Thank you.
Oh, he was done.
Can I respond briefly?
Well, I mean, we're still in the middle of the state's presentation, so yes, y'all both get, since it's your motion, a chance to reply, but not right now.
And here comes Miss Hilton.
Good morning, Your Honor. I'll be addressing the directed verdicts as to counts 2 and 49 of the indictment, which are the murder counts. Count 50, 51, and 57, which are the participation in criminal street gang activity. Counts Mr. Floyd, whenever the court's pleasure, will address the general demurrer as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything? I mean, I took your argument to be essentially, the knowingly and willfully as it applies to RICO, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you have anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted the gang statute. We enacted both. They have slightly different elements, but on this principle, there's really no difference.
Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
All right, 52 isn't the 133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated The relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that's cited in Evans v. State, 360 Georgia Appeals 596, which is a 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented.
Yeah, you really, really need to add that in the light most favorable to the prosecution. Because I'm so happy that isn't the legal standard. But I'm also very disappointed that the judge has so little leeway in granting and dismissing counts in this absolute scam of a RICO trial.
Evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo. In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Demekion Garlington, in which Demekion Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Demas, and Mr. Demas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of which.
Oh, hold on. Iceland has blown up again. Iceland have blown up again. Let's see here. If I can find. If it was caught when it actually started. It's always so okay. Let's keep listening to her while I try to find
There, Mr.
when it
Donovan
actually
Thomas was, which
started.
was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffrey Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the detail of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which is at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside of the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire at and towards the direction of Mr. Donovan Thomas Jr.
Okay, let's break this absolute bore fest for something. Oh, wrong one. This one. These are the live cams from Iceland. You see here how all of a sudden it starts to glow. Playing in 2x speed here. Look up here on the left hand. Okay, now boom, boom, boom. Iceland blowing up again. And this is like half an hour ago, it started. Another Icelandic volcano eruption. This is the 6th volcanic eruption in a year in the same area of Iceland. Now, the town near already have been on alert and is being evacuated. So people are okay. People are okay. Yeah, and you see down here on the bottom, you can see, okay, oh, it's really going off now. And this is less than half an hour ago, apparently. Let's skip ahead a bit and see if you can see the actual. Yeah, oh, look at this. Yeah, Iceland and volcanoes are like the Gulf and hurricanes. There will always be one. Yeah, look at the top left there. Oh, it's going off, and on the bottom right. So this is as I can hear, it is a mile-long fissure that has opened up. A mile-long fissure. Jeez, yeah. Yeah, Pacific Rim. Or Atlantic Rim, in this case. Let me see if I can find another one. RUV is almost always good at this. But not today. Ah, there it is. So yeah, this is live. Afar TV has live footage. Yeah, this is photo taken from maybe 6-7 miles away from the eruption. I've seen similar before, and when I flew back from the United States in August, I saw an eruption through the plane window. So this is a mile-long fissure that has opened up. Ah, this is interesting. But folks, we are here for this. I just wanted to break the bore fest off with something actually interesting happening. So, okay, let's listen to this for a couple of more minutes. Then let's skip ahead to what she actually has to say about the directive.
We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that D'Amico and Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the
yeah, as Sharpa says, is she wearing a bathroom rug? Yeah. Does thy mother know you stole her bathroom rug?
Infinity gray Infinity vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infinity vehicle. You see both of those vehicles leave out of that gas station at the same time. Your Honor, yes, what we do not see is when the transition occurred between Mr. Kendrick getting out of the Bonneville and getting into the Infinity, but we believe there's a reasonable inference that happened off camera outside of, we believe, behind the Texaco gas
Hey,
station.
thanks a lot.
Mr. Copeland also discussed in that interview that
Welcome.
the car that they used was rented by Mr.
I
Jeffrey
tried to make
Williams.
this
We
as
were able to
entertaining
admit
as
State's Exhibit
possible.
334Y, which was a rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams about 2 days before the homicide of Mr. Donovan Thomas Jr. We then also have phone records that corroborated what Mr. Copeland said. We have the phone records that show that when Mr. Copeland woke up in the morning hours, or the afternoon hours, excuse me, of January 10th, 2015, he was located. He told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time. He then proceeded to tell officers that from leaving his girlfriend's house, he went to the green store. The phone records corroborated him going to the green store. The phone records then corroborated what he told police, that he then went to the McDonald's gas station, the McDonald's restaurant, and that's where he met with Demekion Garlington, and that's when Demekion Garlington explained to him everything that occurred. Mr. Copeland was also able to tell the police that Mr. Demise McMullen actually was at the McDonald's when he arrived, or when he met with Mr. Garlington. The phone records corroborate that Mr. McMullen actually made contact with Mr. Williams about 6 minutes after the murder of Donovan Thomas. Immediately following the phone call with Mr. McMullen, there is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, OG Bentley. Both Mr. Copeland and Mr. Zachary in their statements advised that after the murder of Donovan Thomas, that the guns in the vehicle were given to Kelvin Treadwell, also known as OG Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Their phones ping off of the tower closest to Mr. Treadwell's home. So that evidence has come in, Your Honor. We have the autopsy photos that show that Mr. Donovan Thomas was murdered and killed with certain types of shell casings. Your Honor, we have the jail call of Mr. Stillwell. I do not have that exhibit number, which was entered after his preliminary hearing, Your Honor, in which at the preliminary hearing, we know from both Investigator Thorpe and Deputy District Attorney Michael Sprinkle that during the preliminary hearing itself, they didn't use any names. They used witness number 1, witness number 2. However, on the jail calls that we have both with Antonio Sledge and Mr. Stillwell, that they identified one of the witnesses being Little D. Little D was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is, they snitched on me. And I'm paraphrasing. It was never, they lied on me. There was never any other language, but we have that evidence. We have that in evidence. We also have in evidence, Your Honor, State's Exhibit 477NN, which is a slap talk video in which Mr. Stillwell says the words, "I just beat a murder rap, pay my lawyer $30 for that." Also, he has we introduced more recently another song that Mr.
That damn lyrics and songs, and it's, folks, write to your congressman, Senate representative, the Rap Act. It needs to become a reality. The Rap Act, which will not ban lyrics altogether, but forcing prosecutors to actually prove that this is describing an actual crime, not just insinuating. The Rap Act, remember that. Write to your congressman and your senator.
Stillwell has, which was called BS or bullshit. And in that song, he says, "Beat the Hom, no evidence." We believe that that is another reference to the murder of Donovan Thomas. We also have State's Exhibit 436 VV, which is Mr. Stillwell after in 2019 posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from his from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of the crime beyond a reasonable doubt. Next, Your Honor, I will go to count 49, the other murder count in this indictment, Your Honor. Your Honor, the state has admitted crime scene photos of the crime scene at the time. That's going to be State's Exhibit 65, Victor through 115. Victor, specifically 79. Victor has Mr. Shamel Drinks deceased inside of the
We
car.
definitely know he's dead.
Yes, inside of the car. We then have, Your Honor, the surveillance videos from, specifically, I'm going to focus on the BP surveillance video, which is State's Exhibit 116 VV, and the FedEx surveillance video, which is State's Exhibit 117 VV. In both those videos, Your Honor, initially, before we know who was identified, we see a white, extremely darkly tinted Audi vehicle come to the gas station. We also see a white Ford Fusion. We see individuals from those two vehicles enter into the gas station. We later learn that that is both Shannon Stillwell, Quarmavius Nichols, and Miles Farley. We have the evidence that in that same surveillance video, within 5 to 7 minutes after they are at the location, Mr. Drinks arrives at their location in his red vehicle. He is seen walking inside of the store. That surveillance video then shows that when Mr. Drinks' red vehicle leaves, very soon thereafter, both the white Audi that's tinted leaves the location, as well as the white Ford Fusion. We do have a wiretap telephone call, which
This is so stupid. Every piece of evidence you put before the jury tells everybody with functioning eyes, a sound mind, a reasonable juror to say, oh, this is bull crap. You can clearly see it's not Mr. Stillwell who's doing the deed. In every piece of evidence you put forward in that.
is State's Exhibit 437 VV. The call, I can't recall the page number at this time, Your Honor, but the call that is at 9:59 p.m. based upon the wiretap data, which is a call that tells from Demekion Garlington telling another occupant of the white Ford Fusion to immediately get on FaceTime, Your Honor. There's evidence from even Mr. Demekion Garlington's wiretap where they talk about getting on FaceTime when they don't want to discuss certain things on the phone. We also heard that from expert witnesses that FaceTime is a mechanism that is used when criminal activity is going to take a foot because it cannot be tracked. At 9:59, that call takes place. We then see on the FedEx surveillance video at approximately 10:01 p.m., Mr. Drinks arrives at the lights, as well as the white Audi, as well as the white Ford Fusion. The white Audi and the Ford Fusion stay at the light for approximately 2 minutes, Your Honor, before they take off into traffic, running the red lights. Your Honor, at that time, the red vehicle never moves again. We see from the ankle monitor records, Your Honor, based on the evidence that was provided in the ankle monitor records, that within a minute, Mr. Stillwell's ankle monitor goes from 18 miles per hour to 90 miles per hour. We know from the phone records that both cars travel in the same direction towards Fulton Industrial Boulevard, where we believe they go to a music studio. We then have from Mr. Stillwell's phone, a phone note in which, I'll paraphrase, he talks about dropping the ops. Very soon thereafter, and that is right after Mr. Drinks is at that light. We then have, Your Honor, again, phone records that put both Mr. Stillwell, Mr. Farley, Mr. Nichols all in the same area, which is the area of the gas station in and around the same time. Your Honor, we have social media posts. Oftentimes we don't have motive, but we have social media posts in this case that were posted between March 11th, 2022 and March 15th, 2022. One, we know that on March 11th, 2022, the evidence showed that 2 YSL associates were murdered on a highway, both Mr. Christian McMiller and Mr. Darius Ford. And we have in evidence State's Exhibit 452 VV, which is a post from Mr. Stillwell. And I believe this post is on March 11th or maybe March 12th that says, "Just rest, Mac, I got you." Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, "I ain't gonna be the only one crying." Then on March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that Mr. Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a tinted window car place and got deep tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. So, Your Honor, we believe that that evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt. Next, Your Honor, I will go to count 50 and 51, which are both the participation in criminal street gang activity as to Mr. Shannon Stillwell, and then count 57 as to Mr. Diamante Kendrick. Mr. Atkins touched on this somewhat, but I'll just add some additional evidence that has been presented. We have the testimony from investigator Mark Belknap, Trontavia Stevens, Walter Murphy, Antonio Sledge. Well, sometimes it was easy to get out, sometimes it wasn't, but they all have said that YSL is a gang. We have evidence of the tattoos of Mr. Kendrick, which was 518 VV to 520 VV. Which
Before you do the gang counts, can
Yes.
you address the 58 through 61 drugs and machine gun and whether there's evidence of constructive possession for Mr. Kendrick?
Yes, Your Honor. So first with the possession of machine gun, which is count 62.
Yes, sorry.
One, just the proof that of the gun itself, we have the
I know that that's established.
Okay, so as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home
No, he was, okay.
and apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found?
The machine gun is actually downstairs, we believe, in the basement of the home by, underneath
Lay
the
it on the
couch.
floor?
Yes, laying on
Yeah,
the floor
okay.
underneath the couch, Your Honor. It is the state's theory, Your Honor, that when the SWAT team did not make a quiet announcement to get to come into the home, and it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull the, it looks like they pulled the couch back in order to,
Hey, Steph. TV equals Judge thinks your case sucks. Shaking my head. Thanks, Nick. Thank you, Steph JK, for your support of this channel. Thank you so much. Thank you, thank you, thank you.
observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the
And
possession of
gift to the
marijuana
membership.
with intent to distribute, the possession of
Getting us
cocaine,
to
and the possession
27
of
new members
cocaine, Your
today.
Honor. I believe all of these
Thank you so
items,
much.
which was Stacy Exhibit 12XX, 17XX, and 18XX. The marijuana, I believe, was out in the open. If my memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out present and open in the home, Your Honor. That specifically.
Oh, I have to pause here. With Innocent Bystander channel gifting 20 memberships, I believe with that equivalent to $60. Yeah. Honorary Viking. Honorary Viking of today. Innocent Bystander channel. Now, if you want that title for yourself, you need to beat the $60. Yeah, I'm not good at grifting, but I try. So far, with 20 gifted memberships, Innocent Bystander channel, you are dun 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 Honorary Viking of the stream.
18XX was not hidden. 17XX was the marijuana with guns that was found in a cabinet, I believe above the refrigerator inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found
They were
inside.
like in a box in a closet, right?
I believe they were. I thought there was some that was out as well, but of course indulgence. Bathroom upstairs in the house. And then the cocaine was found in the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the on the kitchen counter, and then there's a bag of marijuana that was in that cabinet with the gun
Right.
that's in the cabinet above the, I think, the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor, the evidence that we have is that he was present that day, and we believe that he had been present maybe a few days before.
But not continuously?
Not continuously, no, Your Honor.
And so can you address constructive possession?
Your Honor, it's just the state's position that at the time of Mr. Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with a machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged
That's
both.
the count. Which
That's-
count is that?
Yes, Your Honor.
That's count 63.
Yeah, so count 62 is a machine gun, and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are all of those found? Remind me if you don't mind.
Yeah, there's gotta-
I'm so bored. Let's see if. There he is.
right before the, I'm sorry, that's count 60.
But you're
Okay, here comes Max Chart again.
All right, reply, argument.
Jans Love asks, how can Jack be shot with possession if he wasn't in the home? Like, I'm lost. Yeah. We all ask ourselves that.
I don't feel the need to go on and on, but Your Honor, I just wanted to clarify one thing. I felt that there was kind of a straw man where my argument was being presented about the overt acts alleged that I didn't, the state needs to give a history, and the jury needs to hear about the history of different acts. I'm not saying that those overt acts aren't relevant. And obviously, I mean, we've been in here for a year. They've presented evidence of those overt acts, many of them, not all of them. My assertion and my argument is merely that the state should not be allowed to create an indictment with alleged overt acts that are outside the statute of limitations, and then a listing of those overt acts goes back to the jury as part of the indictment. And that's all I'm arguing with that. Not that it's irrelevant, not that they can't get into it. Because
Yeah,
obviously they
I
have.
understood that to be your argument. I appreciate that. Thank you.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
All right, why don't we take, I don't know if lunch is here yet, but why don't we take a break for a little while? Y'all can see if you can get together and come to whatever agreement you're going to come to on overt acts that there hasn't been evidence presented on. And I want to read the motion that got filed and look at some of the case law and maybe review some of the evidence. And then presuming I don't grant the motion on every count, which I think maybe there's been some acknowledgement that at least a tiny bit of one count might be able to go forward. We need to finish the charge conference. You were going to say something, Mr. Sharp?
I was just going to let Your Honor know that I did. Calling it a chart is really
Okay.
giving it way too much credit. But I did email that to Ms. Pursfield and the state, and I will update it after I confer with the state and
that's
figure
fine.
out.
I didn't mean to oversell what we had put together last night.
It's fine.
One other thing, as far as the charge conference goes, I did submit one additional proposed jury instruction to
I
Ms.
saw that.
Percival.
I'll be interested to hear your argument on that
Thank you.
and the state's response.
Yes, Your Honor. And on that note, we have discussed the charges for the overt acts
Mhm.
that the jury would not otherwise be instructed on, like armed robbery. I just want to let the court and defense know that the state has and is about to submit
Okay.
to the court parties the underlying crimes of the
Okay.
overt acts that are crimes and not otherwise alleged.
All right, thank you.
Your Honor, when it's appropriate, it can be later, but could the lawyers from each side approach about a scheduling matter?
Y'all can do that now.
All right. Thank you to M. Shannon, coming a new member, getting the number up to 28 new members today. We're getting great numbers today. Thank you so much, M. Shannon. Now, I do believe you have been a member before, but maybe you got from gifted to paying it forward, so to speak. But welcome or welcome back. Yay. So they were taking a break. Let's see.
There is.
Yeah, and apparently Law and Crime got problems with their member 6 months. Yay! Yeah, I knew you were a member. I knew you were a member. Now, Law and Crime got problems with their cameras again. So the first couple of minutes, they had to stream from infamous Sylvia's channel. Oh, that was so much fun. While they got new equipment down to court. Oh, that was so fun. Let's see here, skip.
On both.
Okay.
First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution. And doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged? So with regard to the motion for directed verdict on counts 1 to, trying to do these in order. So let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. Let me say that with regard to counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but
Yeah. Folks, this is a statistical anomaly. This is rare, extremely rare with directed verdict. Now, she denied everything but the count, so 3 counts against Jack Gotti. The drug charges and the gun charges. There simply was absolutely zero evidence presented from the prosecution. This makes Doug Weinstein's job during closing arguments much easier with those counts gone. And then they will agree on other counts that are also gone because they are specific against people who are no longer in the trial. So the amount of charges are shrinking, except the RICO and the overt acts in there. But for Mr. Weinstein, his job got a lot easier. Now for Shannon Stillwell. Sadly, the state was allowed to go to lesser charges. Now that in itself also means much lesser time if he gets convicted. But also it makes it easier for Max Chard for his closing argument. Let's keep listening.
it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case, which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of. And so obviously those will get redacted out of the indictment. Let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. And the state even admits they don't have all of the elements for that. So those will be charged as the less.
Yeah, she directed verdict for the greater, but not for the lesser charge. Sadly. Now, as you can see, Law and Crime is using Miss Sylvia's stream because their camera screwed up. So they are using her channel. Sylvia for the rescue. Today again.
it looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the, well, y'all know which ones they were. I don't have them right in front of me. What were they?
52, 64, and 61.
Okay, thank you. All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some
And there they got their live stream up again. But Miss Sylvia was there for the save again.
additions or changes with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions? Your Honor?
Yeah.
Yes,
Okay, maybe we just missed that.
titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions. So y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the teal comments were.
Your Honor, the teal, I tried to capture either items the state believe
Okay.
should come out,
All right.
or words that the state has.
Okay, so we maybe just, as we walk through, you just bring them up to me as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the
Okay.
on this part.
And, Your Honor, since you just emailed us, is it all right if I remain seated because I'm not?
That's fine.
Screen, and are we going to go through what the state emailed to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay. Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay,
And the first one is, I'm going off of.
let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd, which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right?
Well, that's nice. What we said last night.
Can you give me just?
Yeah.
It's called Jury Instructions RICO Draft is what the reline for the email is. And then it's got an attachment.
Yeah, this part is even duller than Mr. Floyd's. Because it's Mr. Floyd again who will argue most of this. But I do believe there are some interesting parts going back to the end of today. So let's skip ahead.
While we were on the break, I think Ms. Persfield caught a couple more charges that need to get included that were, I think, maybe drug charges as well. So we'll get those included. And then we will send out to everyone to take yet another look at these jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. I think when we define the crimes that are just overt acts, they're not counts, that we need to set that off somehow. And I'll just kind of say, hey, you're going to get a list of alleged overt acts, and some of them are crimes. So I'm giving you the definition of those as well. Something like that.
I think that makes sense now.
Okay. All right. So I know the state has provided a jury form that they're going to try to further tailor now that we have a better concept of how we're charging. And I know that was tedious to get through, but I think it was very important that we did it. And it kind of took everybody thinking it through.
Yeah, sadly, those are needed. I don't think the instructions will help the jury much. I'm hoping that most of the jury feels like jury number 56. The way the state has presented this case is beyond belief bad. And that I hope we will get an OJ jury. That, not that I compare this case to the O.J. Simpson case, but it's a very long case. And in the O.J. Simpson trial, the jury took 4 hours to deliberate, returning with a not guilty. That is my hope. No matter what the charges are and the jury verdict forms, they will take the time to write all of them out with not guilty, grab a bite to eat, take a piss, and then hand it over to the judge.
To get to there. So I appreciate that from everybody. And whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Pursfield. We'll look at all of that. I know y'all need to know when we're going to start the closings. The only things we need, and y'all still need to put those stipulations together. Of, certain overt acts that are alleged to also be an act of, a gang act violation. And we've defined those overt act crimes, and we have sort of defined what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be there's like an aggravated assault or something like that and other things. So
there's an attempted murder, there's conspiracy for murder.
Shawfoss asked, do you think Euro number 56 will get passed? I think the prosecution will try. But they already tried once and failed. And this judge does not like changing her rulings, or even Judge Glanville's rulings. So I think the prosecution will try again, but I don't think they will succeed. Now he might be an alternate. We don't know that yet.
we're going to need to
Drug sales.
I think they keep it clean, instead of trying to.
still keep it separate.
Yeah, I think maybe we just.
Okay.
The same thing, except criminal gang activity. However we have.
For purposes of the overt acts includes, okay.
You have them, and I'm just saying, I'm throwing it out because the catch-all says any act of violence, drugs, it lists like the categories. So I mean, an aggravated assault is clearly a violent crime. Just a suggestion to make it less wordy, but
I mean,
I agree with Mr. Biden.
Okay.
I think I do actually agree with Mr. Biden. I think that when we're defining, I don't understand the need. I wasn't going to die on that hill, but I don't understand the need to specifically say
these things
are
equate to.
criminal gang activity, and that applies to when we defined it earlier and now. I think we can just the problem is the definition of criminal gang activity in statute is very long, and then it has the catch-all, and then it becomes,
Yeah.
and then you're making references to different statutes as well. Like certainly I understand crime of violence, but then there's the catch-all, and then we would have to reference the.
John C. Nick, what work will you perform tomorrow? Tomorrow, I am going through something called an FAS. It is about safety in workplace regulations from the government. There have been some laws that are changing on January 1st. So I need to prepare that for next year's negotiations. Yeah. So that's the fun work I have tomorrow.
The RICO statute.
Mm-hmm. And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying? Or what are y'all saying that y'all agree to?
I think I liked what Mr. Abate said, but I also think it's going to get cumbersome if we expect them to parse through everything. But so I would just do it the same way we did it in the first part and just say aggravated, what is it, aggravated battery? Aggravated assault would constitute, if proven, would constitute criminal gang activity.
That goes up first agreement.
Yes.
And where do you want that?
Well, I think if we cut and paste from the first part defining criminal gang or gang act, okay, and we put everything, we copied it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity, instead of putting murder and those other, we just put aggravated assault.
Can I make another suggestion?
Mm-hmm.
Your Honor, is your intention to read to charge on the overt act crimes first or second? Because my thought is, if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, 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 and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue.
I just noticed I am 10 subscribers away from 12,500 subscribers. So if 10 of you who are here, check if you're subscribed or still subscribed. Sometimes YouTube says, hey, let's yeet those out. So please check if you're still subscribed.
That is, the overt acts have to be with the RICO charges. Or we say something,
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to it. It seems confusing if the overt acts are listed way after, totally away from all the RICO.
Maybe charges for overt acts and for parentheses as alleged in count one.
Or if you're doing the overt acts first, you don't have to repeat it the second time
I
when we're
kind of
talking
wasn't
about the
thinking
charge.
about doing the overt acts first.
John C. I guess I should use my membership privileges to find out more about you. I thought farm work or carpentry. Okay. Hi, folks. I do labor law. I'm contracted by a union as a senior negotiator. And I've been doing this line of work for just over 30 years. So that is what I'm doing. Now, I have a farm. And on my members only content on my channel, I show you my farm and the renovations and stuff like that.
I think my ultimate point was, I don't think we need to repeat it twice. We can,
Right.
Whichever time we do it, just refer back to.
All right, the gang counts against Mr. Kendrick and Stillwell are 50, 51, and 57, right? So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah. Murder, possession of marijuana, intent to distribute, possession of a firearm during the commission of a felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, but we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182 unless that is out.
Oh, maybe it's out.
I think that's a leadership.
It's out, it's out, yay.
Is it out? I doubt it.
Okay.
Oh, excellent. Okay.
It is.
I just mean excellent in that it's one less thing we have to deal with.
We said it too.
Okay. All right. Good catch though, Ms. Persefield. So thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, you know, here are the definitions. Here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants. And then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see in the indictment, or as you'll see in the indictment, count one, RICO refers to specific overt acts, some of which are alleged crimes. And then I'm providing these definitions in regards to the overt acts list or something like that.
The question was, any preference as to whether that's done right after I explain RICO or after I explain all of the substantive count crimes?
No preference.
Yeah, I think I'm right after Rico.
Okay.
It makes sense to just close that game.
Okay.
But would you include these charges in the
I'd have to,
paperwork or
things
just
like-
tack them on at the end as an appendix? And then you could say, look, you know,
No, everything I read is going to go out to them.
no, I want it to go out. I'm just wondering if the charges for the overt acts, if you embed it in the middle of the document right after the RICO section, or I think it may be more helpful to help them distinguish these from the acts in the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay with you?
Good idea. The state's nodding assent.
Yeah, that's right.
Okay. Man, look at that. All right, so Ms. Persefield, you noticed something else?
Yes, sorry.
Better now.
We don't have in the overt acts firearm possession, because there's a number of counts that are possession of a firearm by a felon. There's also a couple of counts that are possession of a firearm by a probationer. And then we have the charges against the inmates.
We don't know. The probationer one is the same, is the pattern that you use for possession. of
Yes,
firearms.
substitute probation.
So we'll add that, but then there's several possession of a weapon by an inmate, possession of a phone by an inmate.
I'm doing that one right now.
Okay, the conspiracy for possession by a phone by an inmate. And there's, I don't know if it's in or out, but the Ryan video while incarcerated.
Which number?
Is that a crime?
Act 180. Is that in or out?
It's in.
Right, okay, so I need something on that.
Well, is that a crime?
Right.
I don't know.
We didn't charge it as, we didn't charge the cell phone that he was using.
Okay, all right, but there are some possession of contraband by inmates.
Yeah.
Or acts, alleged acts.
So, isn't, for instance, murder is alleged as an overt act, right? If I am defining all of the crimes that are overt acts first, within the context of RICO, I'm just afraid that I don't know what I'm afraid of. It seems worrisome to me, and to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
My idea was if you use the appendix for for crimes not otherwise defined.
Right, right. I agree with that.
Okay,
All right, but then the order of it, I just don't think,
I would say we would use the, I agree with Mr. Atkins, but I would think that we would do the appendix for the overt acts class.
I agree. That's what I'm thinking.
Well, yeah, the
too.
appendix comes at the end, so.
Right, but when we, when we charge it, when I charge it, instead of
Oh.
saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts. Here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, you know, whatever I'm going to say. My brain's fried at this point,
Yeah,
but
thank you. I'm just a beat
RICO
behind right
refers
now.
to certain overt acts, some of which are crimes. Some of them have already been defined for you, others haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So this is, so basically here under overt acts, this is in the RICO portion.
Doesn't it? I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow. Are you saying put that language there?
Well, that's what I'm wondering, is if this is in the RICO, I mean, not all of the
Yeah.
language, but in
Okay.
reference to
Mhm,
where overt acts would be.
mhm.
Well, can't you just put something in there to the effect of see Appendix A for definitions of,
Well, that's the question.
Okay, yeah, an overt act may, but does not have to be a crime in and of itself. That would be the place to say that. Some of the
Welcome to Georgia RICO. An overt act doesn't even have to be a crime. And the jury only needs to find an agreement of one overt act. And it doesn't even have to be a crime in order for the guys to get sent to prison. I hate the Georgia RICO with a passion.
overt acts alleged in this indictment
are crimes,
are,
are
are,
allegedly crimes?
well, some of the acts alleged in this indictment, if proven,
Would be violations.
would be
Violations of
criminal violations, would be crimes. If proven, would be crimes.
Yeah.
Are you?
Are you typing this or?
I'm not typing this. Nobody's typing this. I'll type it. Some of the acts.
Are you both typing into the same document?
We can.
Would be crimes. Some of the other, if proven, would be crimes. Will have a.
You're skipping ahead a bit.
Okay, so I'll think about that more and come up with some language. So,
Tomorrow is another day.
yeah, it may be tomorrow before that gets hashed out, but
We are working on a redacted indictment as well.
Okay.
So we'll get that tweaked and get that over to the court and everyone as well.
If you send, when you send your message about coming Monday,
Uh-huh.
let them know that we're gonna.
Wednesday.
Wait.
We can certainly not close and charge in
I'm
one
sorry,
day.
not close. I meant
You
to
mean
say charge.
Tuesday?
Charge.
No,
On
but,
Tuesday?
On Tuesday.
but I think they should, if,
Synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Abate is not lying. It's my duty of candor. I have to tell you that
I appreciate that, Mr. Wines, that you take your duty of candor seriously.
very seriously. You're
All right, so closings Monday, maybe
Okay.
we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't.
It's okay, closing Mondays, but they are talking about finishing closing Tuesday. I assume this goes to how long they will. But that goes against the 2-hour rule I've heard about. So, okay, so Monday closing arguments. I assume it will be the state filibustering and the defense coming in with the facts. And then there might be the rebuttal closing on Tuesday. I'm not sure, but I will live stream every second of that. Every second. Now, I might not be able to start the stream, but Dave on Making Law Simple Network has agreed on Monday, if I'm not home, he will start the stream for me.
I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in
I'm
one
sorry,
day.
not close. I meant
You
to
mean
say charge.
Tuesday?
Charge.
No,
On
but,
Tuesday?
On Tuesday.
but I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct? I don't think
Depending
they-
on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday.
What are the hours?
No, for the whole day.
Well, then that gives them a whole day to deliberate.
I
That-
had said, I had told Mr. Matthews we could quit at 2, but Mr. Matthews is no longer in this case. Have we told the jury that? I mean, the jury would,
I don't recall you telling the jury either way about.
Wednesday.
We had that conversation at the bench.
yeah, I don't think I ever did, honestly. So I think they think they're here all day Wednesday. And so they could be here all day Wednesday.
What if if you send, when you send your message about coming Monday,
Uh-huh.
know that we're gonna have extended hours on Monday. We start at 8:30 and we'll go till 7, so all the closings get done Monday.
And just get all of the arguments. We could do that.
First thing Tuesday to the charge.
Well, at 11 a.m. or whenever they're all here, do the charge, get it.
You could extend Tuesday to 7 o'clock, since they're not getting it till 11. Or whatever time.
Mhm.
That's the state's suggestion to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but. And then are you saying have them come deliberate on Wednesday and then take a long weekend and then,
Yes, Your Honor.
okay. All right. That's what we'll do.
Thank you.
Okay. So I still think we all need to get together tomorrow. How about,
Okay, so Monday closing, Tuesday your instructions, and then Thursday it's Thanksgiving. Now that tells me the jury might not be deliberating over Thanksgiving. But is it good for the defense or the state? At this point in time, after watching, I've been covering so many trials, and a bunch of them I'm disappointed in that there wasn't a not guilty verdict. But oh, please let the jury have already concluded that this is a scam trial. So everybody goes home for Thanksgiving.
10?
Oh.
All right.
And there was much rejoicing.
All right. Thanks, everybody.
All right.
Yes, I think so. We're going to have to get back together on jury charges and yeah.
Hey, Your Honor, they woke up Mr. Kendrick at 2 a.m. this morning. I know you don't have control over
In
the
order
sheriff.
to get him here?
They moved him at 2 a.m. They woke him up at 2, moved him to Rice Street for whatever reason, then brought him here because I don't know all the thinking behind it, but come on. Can they please not do that? Especially we have a 10 o'clock start tomorrow. Certainly they don't need to wake him up at 2
No,
a.m. again
I mean,
tonight.
I
I-
agree. I'm not the elected sheriff.
I understand that. I
Doubt if the
understand.
elected sheriff knows that either, frankly, but,
Yeah, that is the prison guards in Fulton County jails. They simply don't see these guys as humans. No, closing is on Monday. Monday. So Monday they will start for you. Will start for me on this channel. Why are they so nasty to Jack? Because they can. because they can. And that's Fulton County jails for you, where the prison guards allegedly should have a rap sheet equal to the inmates.
To my great and devoted deputies, can you all please get word to whomever is in charge of getting the defendants here to, if at all possible, not wake anybody at 2 a.m. to start transporting them for a 10 a.m. court hearing? Thank you. I really appreciate that.
Thank you, Your Honor.
Now, that sounded like a polite question. Judge Whittaker, when she sounds nice like this, she's actually meaning business. Don't piss off a judge. All right. That was, let's just check ahead. Yep. That was the end of today. Directed verdict, hearings and motions. And Jack Gotti got 3 directed verdicts on charges, number 59, 60, and 62, the drug and gun charges. Shannon Stillwell got a directed verdict on the major charges, on some major charges, but lesser included were put in instead. A win is a win. A win is a win. So now we are waiting for closing arguments. Will I cover the more jury instructions and jury charges tomorrow? I don't know. I don't know. I will decide that tomorrow when I get home. Or if I just do a quick recap at the same time as I did today at 5 p.m. Eastern Standard Time. I might do a short recap of it. But other than that, I have some other... I need to get up to speed on the P. Diddy case, so I might do a short stream or a video about that. What has developed in the Adelson case. Then I need to talk to you guys about... what's his face again? I will have content for you. But Monday morning, 9 a.m. Eastern Time, definitely. And don't forget about the Friday panel show. Friday panel show this week will be fundraiser for Lil Rod's appeal. That kid needs to get out of prison. He needs to have his appeal done. And sadly, money speaks. Now, he is appointed a public defender for the appeal. I'm trying to find out if that is a good public appeals defender, or if it is just another public defender. I don't know yet. So, yeah, so that's for Friday at 6 p.m. Eastern Standard Time. All right, folks. Let's go through. Thank you to Denise, who says thank you for the recap. Thank you for your monetary support of this channel. Deja Vu gifted 5 memberships. Thank you so much. Brooklyn gifted a membership. Thank you so much. Innocent Bystander Channel gifted 20 memberships, and with that became honorary Viking of this stream. Steph JK, $2. Thank you so much. Steph JK also gifted a membership. Thank you so much. M. Shannon, not a new member because, as we see here, member for 6 months, but bringing our new members of today to 28. And that, folks, is the end of today's recap. Thank you. Thank you for allowing me to do this. Thank you for your support of this channel. Sadly, Mr. Jingles didn't make an appearance today, but you can't. It's a cat. He decides when he wants to show up or not. Oh, all right. What a day. What a day. And folks, remember, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. I will see you in the next stream or video. All right? Thank you. Bye-bye.